The DOJ revealing it needs more time to review 1 million new documents potentially related to the Epstein case. The Department of Justice now says it will take a few more weeks to release all the files, and the backlash is mounting.
1 million more documents potentially related to the Jeffrey Epstein case.
The U.S. Department of Justice has issued an official acknowledgement that it has discovered more than 1 million additional documents directly related to the Jeffrey Epstein case. 1 million documents? The number alone is staggering, and it immediately ignites an unavoidable question. If these records existed, where have they been for years? And why were they only found after Congress forced disclosure? According to DOJ itself, the newly identified materials came from the Southern District of New York Prosecutor's Office and the FBI, the very agencies that led the investigation and prosecution of Epstein and later the case against Ghislaine Maxwell. That fact makes any claim of "we didn't know" extremely difficult to defend. If these were the core agencies handling the case, the idea that such a massive body of evidence was never fully cataloged, processed, or disclosed for years is institutionally indefensible. Against that backdrop, DOJ has admitted it is now in a full-scale sprint. More than 200 attorneys have been mobilized to review the files. Prosecutors in Florida have been instructed to work through holidays. Internal emails describe an emergency situation, understaffed, short on time, and facing a volume of records far beyond normal capacity. But for Congress, these explanations do not change the core issue. The law set clear deadlines, and DOJ failed to meet them. What truly pushed this crisis beyond control, however, was not just the volume of documents or the missed deadlines. It was the release of an internal prosecutorial email that landed like a political bombshell. In that email, prosecutors explicitly confirmed the existence of at least 10 co-conspirators in Epstein's trafficking network. Not speculation, not rumor. The language is direct, co-conspirators. The email details that some of these co-conspirators were subpoenaed before a grand jury. Others were being sought across multiple states, that the FBI was receiving dozens of tip calls, and that prosecutorial teams were actively interviewing scores of victims. Written in the technical language of federal prosecutors, these statements shatter the long-standing narrative that Epstein acted alone or with only a minimal number of accomplices. In the U.S. justice system, the term co-conspirator is not casual language. It is not used loosely, and it is not political rhetoric at your church. Former federal prosecutors note that when a prosecutor labels someone a co-conspirator, whether in internal documents or formal communications, it means they believe there is sufficient criminal evidence to establish participation in a criminal conspiracy. And legally, once that conclusion is reached, accountability must follow one of three paths: prosecution, a plea agreement, or a formal grant of immunity in exchange for cooperation. The problem is that none of those paths appear to have been applied to the 10 co-conspirators referenced in the email. There are no indictments, no plea deals, no public immunity agreements. This raises a systemic question. Why was Ghislaine Maxwell prosecuted, convicted, and sentenced to a lengthy prison term, while individuals identified as Epstein's co-conspirators seemingly vanished from the justice process? That question becomes even more sensitive when placed alongside prior public statements by Kash Patel. In congressional testimony, no broader network, no uncharged co-conspirators. At the time, those statements were treated as assurances from the highest levels of law enforcement. The newly released prosecutorial email creates a direct contradiction. On one side, sworn testimony to Congress. On the other, internal documents from prosecutors who handled the case. Both cannot be true, and when such a contradiction emerges, the consequences extend beyond political controversy into real legal risk. Under federal law, providing false or misleading information to Congress can constitute a criminal offense. If it is shown that senior officials were aware of co-conspirators yet denied their existence before Congress, they could face exposure for lying to Congress or even obstruction of justice. At this point, those questions are no longer hypothetical. What is now clear is that the Epstein files have moved far beyond the scope of an ordinary criminal case. They have become a stress test for the entire system, from DOJ to the White House to Congress itself. And what has been revealed so far may only be the visible tip of a much larger political iceberg. Since the internal prosecutorial email became public, The Epstein case is no longer about administrative delays or document overload. It has crossed into a different realm: political accountability and individual legal responsibility. Once evidence shows that co-conspirators were formally identified using prosecutorial language, the question is no longer whether, but who knew, when they knew, and why it was denied. It is at this point that impeachment enters congressional discussion, not as a political slogan, but as a constitutional enforcement tool placed squarely on the table. Several lawmakers emphasize that the core issue is not the contents of any single Epstein document, but DOJ's failure to comply with the law enacted by Congress. Under that logic, missed deadlines combined with potential concealment or excessive redactions could constitute contempt of Congress. The pressure now focuses directly on Pam Bondi's. As Attorney General, Bondi carries not only general political responsibility, but personal responsibility to ensure DOJ complies with the law. Lawmakers frame the argument simply but forcefully. If the law requires disclosure and DOJ failed to deliver, who is accountable? And if the explanation is not enough time or too many documents, then the next question is unavoidable. Why were these documents only discovered after the law took effect? The impeachment risk is magnified by the nature of the Epstein case itself. This is not a routine prosecution. It involves minor victims, organized trafficking allegations, and potential links to powerful individuals. In such cases, the standard for transparency is not lower, it is higher. Any sign of delay, concealment, or selective enforcement is immediately interpreted as protection of someone. That is where the question of motive enters the public discussion, not as an outright accusation, but through a chain of logical inquiries. If prosecutors identified 10 co-conspirators, why was none prosecuted? If they were not prosecuted, were immunity deals made? If so, why were those deals never disclosed? And if not, what stopped the normal course of justice? This brings renewed focus to Kash Patel's testimony, when a senior official told Congress that Epstein did not traffic for anyone else. That was not merely an opinion, it was an official assurance to the legislative branch. When that assurance conflicts with prosecutors' own internal records, the issue becomes not disagreement, but the possibility of misleading Congress. Federal law makes clear that lying to or misleading Congress, whether under oath or not, can constitute a criminal offense. This is especially serious in hearings tied to oversight of executive power. If Congress establishes that false statements were used to obstruct oversight, the charge can escalate to obstruction of justice. In a more extreme scenario, it could be viewed as participation in a coordinated cover-up. As a result, debate in Washington is no longer centered on what Epstein did, but on what the system did after Epstein.